Good morning. The meeting will now come to order. Welcome to this meeting of the Charlotte Unified Development Board of Adjustment on Tuesday, November 18th, 2025. My name is Deborah Dryden, and I am chair of the board. Would the board members please go around and state their name for the record? Mr. Williamson?
Marshall Williamson. Kevin Shea.
Hamilton Court.
Emily Sun.
Thank you. Also present are Solomon Fortune, our zoning administrator, John Kinley, our senior project manager, Crystal Monsegur, our planner, Teree Hagler Gray, our senior assistant city attorney and advisor to the board, Paige Inman, assistant city attorney, advisor to the board, and Elizabeth Majors, our Veritex court reporter. Each of today's hearings is a quasi-judicial evidentiary hearing. That means it is like a court hearing. State law sets specific procedures and rules concerning how this board must make its decision. These rules are different from other types of land use decisions like rezoning cases. The board's discretion is limited. The board must base its decision upon competent, relevant, and substantial evidence in the record. A quasi-judicial decision is not a popularity contest. It is a decision constrained by the standards in the ordinance and based on the facts presented. If you will be speaking as a witness, please focus on the facts and ordinance standards, not personal preference or opinion. General witness testimony is limited to facts. For certain topics, this board needs to hear opinion testimony from expert witnesses. These topics include projections about impacts on property values and projections about impacts of increased traffic. Individuals providing expert opinion must be qualified as experts and provide the factual evidence upon which they base their expert opinion. While hearsay evidence is not specifically excluded, it is only given limited weight. Parties with standing have rights to participate fully. Parties may present evidence, call witnesses, and make legal arguments. Parties are limited to the applicant, the city, and individuals who can show they will suffer specific damages. Other individuals may provide testimony as witnesses when recognized by the board. Witnesses must swear or affirm their testimony. Any individual wishing to speak as a witness today was required to sign up. If you haven't done so, please do so now. Excuse me. Oh, thank you. Excuse me. The parties to each case are entitled to an impartial decision maker. A board member may not participate in a hearing if they have a fixed opinion about the matter, a financial interest in the outcome of the matter, or a close familial, business, or associational relationship with an affected person. The parties to each case also have a right for any ex parte communication to be disclosed. Ex parte communication is any communication about the case outside of the hearing. That may include site visits as well as conversations with parties or the general public. At the start of each case, any potential conflict of interest or ex parte communication should be disclosed by a board member if applicable. These matters may also be raised by an affected party. Today's meeting will follow the order printed on the agenda. The order of the regular agenda will be as follows. All parties who plan to give testimony must be sworn in. A city staff member will present a summary of the case. The board may question the staff member, and then the applicant may question the staff member. The applicant presents their testimony for the case, and any sworn witnesses provide testimony. The board and city staff may question the applicant and their witnesses. Other parties wishing to speak for or against a case will be given reasonable time to present sworn testimony. The staff and the applicant will be given the opportunity for rebuttal. After hearing each case, the board will review each case and render a decision. This decision is usually done in closed deliberation after hearing each case. The chairperson calls for a motion and a second to approve or deny the variance or appeal. The decision will be made by a simple majority vote of the board. However, the board may elect to take up to 30 days to render a decision. You may remain present during the deliberations, or you may call the zoning office staff after the session to receive the decision of the board. If you wish to receive a written copy of the decision letter, please indicate so on the sign-in sheet. All exhibits must remain with the board. If your case is not appealed to Superior Court after 30 days, you may pick them up or they will be destroyed. Appeal from this board to the Mecklenburg County Superior Court. You may have 30 days from the date of the board's written decision in which to appeal in accordance with NCGS 160D-405D. All right, I'm going to now swear in our city officials. So if you gentlemen will stand, please. All right. Do you solemnly swear to affirm that the evidence you shall give will be the truth, the whole, what, if you give in this act to the board in this action shall be the truth, the whole truth, and nothing but the truth? Thank you very much. All right, before we begin, it's been brought to my attention, board, that the second case, variance 2025-00044, has requested to defer to the 16th. Next month. Do I hear a motion to approve that?
Court, move to approve that.
Thank you, Mr. Court. Do I hear a second?
Sun second.
Ms. Sun, second. Mr. Williamson,
Williamson, yes.
Mr. Shea,
Shay, yes.
Ms. Sun,
Sun, yes.
Mr. Court.
Court, yes.
Okay, so that variance number 2025-00044 has been deferred until next month. Okay. All right, we'll now open the evidentiary hearing for variance number 2025-00043. The property is located at 219 Greenwich Road. Before we begin, does any board member have a conflict of interest or potential conflict or any ex parte communication they need to disclose?
No, ma'am.
Thank you very much. All right. All right, Mr. Kinley, you may begin.
All right, this is application variance VAR 2025-00043 by Ken Fleming of JMH Real Estate LLC, represented by Rick Korvick, and property is located at 219 Greenwich Road. Parcel is owned by JMH Real Estate LLC, and it's a variance from UDO Article 19.6.A.2.B, Table 19-4, to allow surface parking driveways and circulation and maneuvering areas within the required setback. Here's a vicinity map on Exhibit 1 of the presentation. The site is off of Randolph Road, basically in the Cotswold Shopping Center area, right before you get to the Cotswold Elementary School's entrance off of Greenwich Road. So kind of behind the Publix and Chick-fil-A in that area. There's some office buildings that are right there and off of that street. Here's an aerial map on Exhibit 2 showing the existing building and the area of parking in the front that we're going to be looking at. It's kind of that whitish colored concrete. You can see the school's building to the right hand side of the screen or to the east, and then the other office buildings to the left. There's a new apartment building that's being constructed at the bottom of the screen off of, I forget the side street, but there's an apartment building that's under construction there in that area as well.
Colwick.
Yes, Colwick, that's right.
Oh.
Exhibit 3 is a zoning map. The property is zoned OFC, Office Flex Campus Zoning District. And here's just a bird's eye kind of view of the property on Exhibit 4, again showing the location of the existing building and the parking and driveway areas as it relates to the others in the area. So it's a variance from the Article 19.6A2B, Table 19-4, and that section says that surface parking driveways, circulation, and maneuvering areas may be located in the established setback along a street. However, those are prohibited in the required setback. As a part of this variance that we are, and the applicant has agreed to a condition that the pavement for the standard parking space and a triangular area of approximately 115 square feet between the standard space and the driveway aisle will be removed, and landscaping and screening shrubs or a screen wall matching the standards of Article 20.5B3 and 4, which are the standards for landscape screening or screen wall, would be provided between the handicap space and the driveway aisle, and I'll indicate where that's at on the site plan. And this was exhibit number 5 for the variance request. Exhibit 6 is the site layout. Shows the existing building, some existing parking at the rear of the building. The site, the way it was set up, had a kind of a narrow driveway along the side of the building that goes back to this existing parking. And prior to this being installed, there was only the single driveway in and out of the property. This area that's shaded in green is the standard parking space, and the small triangular area that, as the condition of this variance request, we've asked to be removed, and kind of get into the details of that. Can I get a copy of it? So the, let's see. Where did I say that? Comes up a little bit later, but so according to the applicant's variance application, the applicant had hired a contractor to install a secondary driveway and parking spaces to address accessibility and safety issues. However, the contractor failed to inform the applicant that a permit approval was necessary. So that's kind of how we got to where we are now, where there's this parking already in existence. And the resulting condition of, well, we want you to remove some of that because it wasn't permitted. Installing the proper and appropriate landscape screening or screen wall that the code would normally require when you have parking in front of a building between the parking in the street. And then but still allowing for the variance request to allow this maneuvering and accessible space to be located here. And we'll kind of show you exactly why as we go into the next slides here. So again, this is street view image in exhibit number 7 showing Greenwich Drive. This is an older picture from Google, but you can see that their driveway was right here, and that was their only point of ingress and egress into the property. The school's little roundabout thing that they have is literally just beyond that, and then there's another driveway over here. So when school is in session and kids are being dropped off and picked up, traffic tends to line up on Greenwich Road, and so they were limited in their ability to get in and out safely into the property. So that's why they added basically the circle drive in the front, just to give them another way to get in and out, not having to back out into the street and that sort of thing. And then you can see in this lower view, the Google Street View conveniently drove into the property. You can tell here that there's not an accessible entrance into this building. There's a staircase. So anybody that needed accessibility to get into the building would have to park here and then go around the building to the front. So staff is comfortable with allowing a variance to let the handicap parking space remain in the front while also making the accommodations for that second driveway entrance and exit point further down.
Oh, one more. Which side of, is it the school is on the right-hand side?
Yeah, the school is here. Greenwich ends right at the school's property.
Has there been a review of the dimensions of the handicap space? There's usually a 7-foot loading zone next to handicap space.
We didn't review it for all the dimensional details, but we are giving them some flexibility to, modify that as necessary in the area that they remove for the standard space. We'll be flexible with them to make sure that the handicap accessible space meets the ADA requirements. Exhibit 8 is the variance criteria. As a reminder, all 4 of the criteria need to be met in order to grant the variance, and I'll give you all a minute to look over the findings before I continue.
So are they still gonna have curved, or is it just gonna be straight in?
There would be a circular driveway.
It's still gonna be
Yeah,
circular.
yeah.
I would say if it was just back out, they're not solving it. Okay, you may continue.
So one thing I didn't point out and before is, so one in the considerations in Exhibit 6, the site layout, is that the required setback comes nearly to the front of the building. I think in number 6 in the findings, the established setback is 41 feet and the required setback is 36 feet. So there's only about 5 feet between the face of the building and the required setback line. So pretty much all of the property in front of the building is within that required setback. And again, that required setback would prohibit any sort of parking and maneuvering in front of the building. Unnecessary hardship results from the strict application of the ordinance, and the site does not have an accessible parking space near the front entrance of the building. And vehicular access to the site at times can be limited by school traffic, and the applicant installed the parking and secondary driveway to address those issues. However, strict application of the ordinance standards prevents all parking and maneuvering between the building and the street for the subject lot. The hardship results from conditions that are peculiar to the property. The lot is the last property on the left side of Greenwich Road prior to the dead end into the driveway for Cotswold Elementary. And the school's driveway is used by buses and parents to drop off and pick up students. The proximity of the site's primary driveway to the school's driveway creates unsafe conditions for the site's employees and customers and those entering and exiting the school property. The lot slopes down about 10 feet from Greenwich Road to the rear of the lot, and there's a small parking area to the rear of the building that's accessible by a driveway to the right side of the building. The topography and the layout of the building and parking restricts accommodations for persons with disabilities. Hardship does not result from actions that were taken by the applicant or the property owner. Again, according to the applicant's variance application, the applicant had hired a contractor to install this secondary driveway and parking area to address the accessibility and safety issues. However, the contractor had failed to inform the applicant that permit approval is necessary. And additionally, the hardship results from the unique location of the site and the site's layout and strict application of the ordinance. And the requested variance is consistent with the spirit and purpose and intent of the ordinance, and that public safety is secured and substantial justice is achieved. Granting the variance will allow for an accessible parking space near the front door of the existing building. Granting the variance will provide a secondary vehicular access and egress and ingress point to the property, providing access options during school drop-off and pickup times, providing safer vehicular movements at the site and school's driveway. Applicant has agreed to the staff's requested condition that the pavement for the standard parking space and triangular area of approximately 115 feet between the standard space and the drive aisle will be removed, and a landscaping and screening shrubs or a screen wall that matches the standards of Article 20.5 B, 3, and 4 will be provided between the handicap space and the driveway aisle. And granting the variance would not alter the essential character of the area. Properties in the area are developed with commercial and office uses, and a lot of them have multiple driveways and parking between the building and street. And last slide is just a photo at the corner of the property, and that concludes our presentation.
Questions?
Is there any concern about impervious coverage over that setback? And seems like that's at the top of the road and everything drains downhill to his neighbors. Is that gonna cause stormwater issues later? Or is it causing them now? Do we know?
So what is gonna happen is when we go through land development review, our stormwater reviews, we'll look into that because we've got place permits, our stormwater team did not have a chance to that.
Okay.
Yeah, they will, because they didn't get permits for it before, they will still need to go through the permitting process to make sure that the full review is done, and that everything meets the ordinance standards outside of the parking and the setback.
This driveway is not poured yet?
No, it's been poured. But they would be basically doing an after the fact permit.
Understood.
The variance is simply to allow the parking and driveway area to exist in front of the building, but they still would need to meet all the other standards of the ordinance.
They just need to put the cart before the horse.
Right.
Are they allowed 2 driveway entrances by right? Or do they have to
There's,
apply?
there's not a limitation. They would need to get a driveway permit from CDOT if one hasn't already been granted, but from a zoning perspective, there's not a limitation on the number of driveways that you have.
Is there any more information about sidewalks in the area and adjacent properties?
I'm not sure if there's any plans for installing additional sidewalks or changing the sidewalks in the area.
It's just current points right now until development comes by, we won't get new sidewalks because the schools do stuff, but there's always sidewalks.
Seems like this is development coming by though.
Oh, well.
So, I mean, if we're waiting for developers to improve the property to install sidewalks, and this is a developer improving the property. There's a sidewalk on the other side of the street. There's no sidewalk on this side of the street. I mean, this is right next to a school, and that sidewalk on the other side of the street is forcing everybody who walks to the school to cross that street where all the traffic lines up. Having a sidewalk on the side of the street that the school's on seems like it would be safer, and installing, allowing a variance for things that might make it more difficult to build a sidewalk in the future might be a problem.
Don't know what the future plans are for the school because they have started construction of the new buildings that they're doing out here. So currently there's a sidewalk along the right-hand side of Greenwich that goes into the school building. You can see there's a little crosswalk here to the main school building. On this side, it mostly goes to like the drop-off area, I guess, or school bus circulation. So I don't know what their future plans are on this side of the property. Whether or not there'll be like students and internal circulation, that sort of thing. But the ordinance basically says that if you are doing a new building or doing an addition to a building or doing parking of more than 10 parking spaces, then you trigger streetscape improvements. So this addition of parking in the front would not trigger those streetscape improvements because the existing building is remaining. They're not changing anything with the building in terms of doing an addition or anything like that to it.
And Solomon, is there a width limit for the driveway?
I mean, it depends upon what they're doing. So typically the standard for CDOT is, you might get a 20-foot driveway width because if it's two-way option, they can narrow it down to 10 because they're doing the circular in one way in and one way out. So it just depends upon what the reviewer, they look at it based upon speed of the road and the number of cars they look at when you come through land development.
So if it's circular, it can be 10, it's still.
You could drop, yes, you could go to smaller because it would be, the assumption would be if someone's coming in, they would go out the other way while someone's coming in. So that way there's too much, but typically if it's a two-way maneuverability on the same street, then you're going to get to that 20 feet is roughly what their CDOT's looking for.
Okay, thanks.
Any other questions or comments, staff?
Well, can you get back to the screen wall? Yeah, so the condition is that they'll install a screen wall and landscape screening, and it's 115 square feet.
So their site plan showed a handicap space and a standard parking space next to it.
Mm-hmm.
What we're asking is that they remove the standard parking space and a triangular area. This triangular area is about 115 square feet.
Okay.
So I don't know what the area of the standard parking space is, but it's, yeah. Yeah. And it would be a landscape screening or a screen wall. The ordinance gives you the option to use either option to screen parking between the street and the building.
So if that screen wall was forced to get closer to the street, you'd still have 115 square feet. You're not going to be reducing that?
Right.
Okay.
I mean, I understand why they're asking. I mean, if any of you have ever sat in school traffic waiting, because parents are notorious for it, they don't care. They're just gonna get in line. And trying to get in and out of a business when the street is lined with cars twice a day. And I am sympathetic to the fact that there's no handicap parking. Because that's pretty essential for today to have something that's, I mean, handicap parking means that it's supposed to be closer, I thought, to the building and more accessible to the front entrance. So I can see why they would ask for the circular drive so that they have a little bit of maneuverability. I don't know, in their plans, they said so they wouldn't have to back out, but I mean, if you're parking in the back, it would seem like you could turn around and come out face front from there. But I think for me, it's a pretty good compromise. They're going to put in the landscaping and the screening, and they are at their expense taking out what the other contractor did. I guess a cautionary tale to people to make sure that, because ultimately it's the business's responsibility that they didn't pull a permit. I mean, he can blame the contractor all he wants, but bottom line is it was his responsibility to follow through and make sure that there was permitting there for that. Any other comments, questions?
I'd make a motion to approve with conditions.
So, hang on just 1 second. I believe that there are folks that are signed up to speak. Is that correct?
All in favor.
Okay.
My motion stands.
Yes. Okay, Mr. Shea made a motion to approve with conditions. Do I hear a second?
1 second.
Ms. Sun, thank you very much. Mr. Williamson,
Williamson, yes.
Mr. Shea,
Shay, yes.
Mr. Court,
Or yes.
Ms. Sun,
Yes.
Dryden, yes. So the variance is approved with conditions stated in the staff recommendations. All right, we need to approve the finding of facts and conclusions of law. Do I hear a motion?
Edit on number 11.
Edit for number 11 should be,
Existing should be exiting in the last sentence.
those entering and exiting the school property?
Yep.
That's what mine says.
Mine's
Oh.
Existing.
Mine says existing.
Oh, entering and exiting. Oh,
Yeah, what to miss it?
I'm sorry, I missed the S. Okay, so, all right, we're looking to approve the finding of facts and conclusions of law as amended in number 11 with the conditions. Do I hear a motion?
Court moved to approve
1
as,
second.
as stated,
Okay,
As
Mr.
amended, correct?
As revised.
as amended, yes.
Yes, Mr. Court as amended.
1 second.
Thanks, Ms. Sun. All right, Mr. Williamson,
Williamson, yes.
Mr. Shea,
Shay, yes.
Mr. Court,
Court, yes.
Ms. Sun,
Yes.
Dryden, yes. So the finding of facts and conclusions of law are approved as amended. Thank you very much. Thank you.
Mr. Dryden,
Here you go.
we're going to
Let me try.
proceed to number 46 because
We have,
we don't have applicants here for 45, so we'll let these people go ahead and get their case.
Okay, that's fine. All right, so we are going to move now to variance number 2025-00046, correct?
Yep.
Okay, this is for property located at 4941 Virginian Lane. Right, Mr.
Okay, this is by Matthew William Manning, represented by David Murray of Murray Law for property located at 4941 Virginian Lane. And it's owned by Matthew William Manning, and they are seeking 4 variance items, all for the same issue, but there's 4 different sections of the ordinance that come into play, which is a little bit complicated, but I'll just kind of quickly read through those. So it's variance from Article 4, Table 4-2, Row B, to reduce the corner side setback from 13.5 feet to 7 feet, which is a 6.5 foot reduction. A variance from Article 17.2.E to reduce the required garage setback from 20 feet to 7 feet. That's 13-foot reduction. A variance from UDO Article 19.6 .A.1.A3C to reduce the required driveway length from 20 feet to 7 feet, a 13-foot reduction, and a variance from Article 19.6.A.1.A3D to reduce the required garage door setback from 20 feet to 7 feet, a 13-foot reduction. So Exhibit 1 is the vicinity map. This is down near Highway 51 and 40, I think, yeah, 45, kind of off of, I guess it'd be east of Carmel Road. Exhibit 2 is the zoning map. The property is zoned N1A, Neighborhood 1 zoning district. And you can see the layout of the buildings on the parcel on the map as well. And Exhibit 3 is a close-up aerial map. Again, this is the garage we're talking about, and the variances we're discussing are all related to this garage and its setback off of the road here. So it's 4 variances. Again, here's the sections. Table 4-2, Row B, says that a corner side setback is 13.5 feet in the N1A zoning. 17.2.E says that detached carports shall be a minimum of 20 feet from the right of way or the back of sidewalk, whichever is greater, to allow a minimum driveway pad of a length of 20 feet. And then Article 19.6, C and D, or A1, A3, C and D, says that driveways and parking pad spaces shall be a minimum of 20 feet in length. And then this says that garage doors for garages need to be a distance of 20 feet back from the right of way or back of sidewalk, whichever is greater.
John, just to be, yeah, go to the next one.
Yep.
So it is not attached.
It is not. No, so we're talking about a detached garage here. And detached garages can be located in the corner side setback, but they have to meet all of those, or the established corner side setback, but they need to meet the 13.5 foot setback. And or if they have garage doors facing the road, then they need to have a 20-foot setback from the garage door and face the garage to the right of way. The corner side setback is indicated with this small dash line. This does have a platted setback of 20 feet. That's this larger setback. The zoning ordinance doesn't supersede or does supersede plats for corner side setbacks. However, if it's like a deed restriction, we don't enforce the deed restriction. So they would be responsible to meet whatever was in their deed restriction if that's the case. However, it still would be 20 feet, which is basically this the longer dash line.
Well, what triggered this request to?
So yeah, we're gonna get into that. And that is under findings. In their findings, it's number 9 through be 9 through 13 essentially in the findings. So in 2019, the previous homeowner, not the applicant and the current property owner, but the previous owner it might even been 2 owners before, I'm not sure. But anyway, a previous property owner, somebody who's not involved now, got a permit to build the detached garage, a 26 by 24 foot detached garage. And you can see on the plot plan, it indicates 22 feet from Flagstop Court, which is the side street off of Virginian, and a 20-foot setback. Mr. Murray kindly went out and measured it for us from the edge of the curb to not quite to the face of the door is exactly 20 feet. So what we believe happened was that whoever was contracted or permitted this, they indicated properly the correct setback of 20 feet. But then in reality, when they went out, this doesn't say anything anywhere in here about being from the right of way. It says it just shows from Flagstop Court. So what we assume happened is that whoever was going out measuring the distances for that setback was measuring from the back of the curb rather than the right of way, which sits further in. And if you look at the survey, the right of way is this line. And here's the curb. So it's a pretty substantial distance between the curb and the right of way here.
A plus in your graphics, by the way, A plus.
So basically where we end up with is a garage being 7.3 feet from the right of way. But it's 20-ish feet from the curb. So they have space outside of the actual travel lanes for cars to be parked and maneuver out of the street, but it's within the right of way, unfortunately.
They're not moving the existing garage.
No, nothing would be changing. This is only to facilitate the future sale of this property that the applicants currently own. And I think the current buyer's survey is what brought this to the attention of the current property owner. So again, even with a rough estimate on Polaris from the edge of the pavement to the face of the garage, it's 22 feet, which is exactly what the permit showed. Here's a street view on Exhibit 8, showing the garage and that slope down to the street. And exhibit number 9 is the variance criteria. Again, all 4 of these need to be met in order to grant the variance, and I'll give you all a minute to look at the findings if you want before I continue.
John, I have a question. So all of the setbacks needs to be measured from the right of way, not the curb, right?
That's correct.
Okay, thanks.
And the right of way is about halfway through the street, isn't it? I mean, well, about that. Yeah.
I don't know the exact dimensions, but the right of way is bigger than, I think it's a 50-foot right of way. The
Mhm.
street is not 50 feet wide.
Right.
With no sidewalks.
Okay, John, you may continue.
All right. One thing I'll mention is, and I think it's in our findings as well, there is a condition, the variance would only be applicable to the garage or accessory structure and its replacement if damaged or destroyed as set forth in Article 38.3G. So the unnecessary hardship does result from the strict application of the ordinance because the structure would have to be demolished and rebuilt to comply with the ordinance. Demolition and reconstruction compliant with the ordinance would impact existing trees and existing deck and cause undue hardship on the applicant who did not own the property at the time that it was constructed. The hardship does result from the conditions that are peculiar to the property. The hardship is related to the location of the lot on a corner and the distance between the actual lot line and the edge of the street on Flagstop Court and the existing permitted garage, and the garage location is peculiar condition at this property. The hardship doesn't result from actions that were taken by the applicant. The garage was built by a previous owner in 2019 prior to the applicant's purchase of the property in 2021. The garage was permitted in 2019 and the plot plan associated with the permit shows a 20-foot setback and the garage to be located 22 feet from Flagstop Court, consistent with the ordinance requirements. However, the garage was mistakenly built within 22 feet of the edge of pavement rather than the right of way. And the plot plan does not show the street right of way and does not specify that the setback is measured from the right of way. The applicant purchased the property without the knowledge of this encroachment, and the applicant did not build or change in any way the garage structure that exists on the property. The property is under contract to sell and the violation was discovered when the buyer obtained a survey and the applicant is requesting variances to bring it into conformity so that the sale can be concluded.
Can I ask you a question of,
Mhm.
just as you go, Beth, that when the permit was originally issued in 2019, is this something that we would catch now with the permitting process?
Yes. Yes, we would. So we've been working with our staff to say, hey, we are going away from hand sketches like that, because again, that's exactly what happened is the staff didn't, and someone didn't pull an aerial and say, hey, you should be measuring this from edge of right of way, not the back of curb. So now obviously we're gonna have these incidents all across the city, but yes, going for the UDO, we have told staff that applicants, we need to, as a city, we need to move on from
Yeah, the little.
crayon drawings and napkins.
So are you gonna require a survey?
We're not trying to require surveys, but it'd be staff basically telling, hey, if someone draws something, you need to look at it more closely as in seeing where they're measuring it from, because like here, John's correct, when you look at
They
it.
should have shown a right of way.
They should have shown right of way line and labeled that, and then when we would have approved it, we would have been able to come back and say, hey, staff reviewed it properly, because right now, there's kind of like, I can point the blame at, was it the person who built it, or was it staff?
Okay.
If you ever add a checklist to your application, that would be a good checklist item is right of way
So we do. We have checklists for our review staff.
or applicant.
We have that too for the applicant, but let's be fair to applicants. A lot of times when it's especially for single family homes, it's people who deal with government one time in their life and they will never deal with us again.
Right.
And so they're not always as I like to say, they don't always necessarily know jargons of land development terms, and
What is it right away?
that's correct.
John,
So,
my own knowledge. When did this, we're here today on the 18th, when did these folks come to you for this application?
Chris will look it up. I'm gonna continue if you don't mind.
Yeah, go ahead.
Look that up. The requested variances are consistent with the spirit, purpose, and intent of the ordinance in that public safety is secured and since substantial justice is achieved. The garage has existed in its current position since 2019. The setback encroachment is not obvious because of the distance of the garage door to the face or to the edge of the street. It was built with permits and the plot plan was submitted by the prior owner, and builder indicated that they were under the belief that the setback for the garage was measured from the edge of street, which was according to the plot plan as 22 feet. However, the actual distance from the right of way is only 7.3 feet because the right of way is approximately 15 feet from the edge of pavement. So there was that, you were asking about that, Ms. Dryden, about that distance. So it's unlikely that Flagstop Court would be widened because of its location within a residential. There's a missing word there. Location within a residential nature. I think that should be within a neighborhood and residential nature. There are no plans to add sidewalks to Flagstop Court in the future. The distance between the garage door and the edge of the street is over 20 feet, providing space for vehicles to pull out of the travel lane so that they do not impede the flow of traffic or pedestrians walking within the street. An applicant has offered and agreed to the condition that the variances are only applicable to the garage accessory structure and its replacement if damaged or destroyed as set forth in Article 38.3G. The garage does not encroach into the right of way. Granting the variances would not alter the essential character of the neighborhood. And did you find that?
It is October 10th, 2025.
Go pretty quick, go 6 weeks.
All right, so you said that sentence should read, it's unlikely that Flagstop Court will be widened because of its location within a neighborhood
And its resident.
and its residential neighborhood.
Yeah, for residential nature.
Residential nature, okay, thank you.
Do you have a vicinity map that shows the nearest collector street?
Let's go back. So the nearest collector street would probably, I think all of these.
It's way
all of these are locals.
Yeah, it's
So Carmel Road, which is probably an arterial.
a quarter mile off of,
Yeah.
away from a collector.
Do we, Do we have anybody in opposition to this speaking today?
No, no opposition.
Okay.
I make a motion to approve.
Okay, thank you. All right, with conditions,
With conditions, sorry.
all right,
Make a motion to approve with condition.
Mr. Williamson has made a motion to approve with a condition that, you know, it can only, the condition
As
is
stated by staff.
as stated by staff. There we go. Condition as stated by staff. Okay.
Court second.
All right, Mr. Court, thank you. Okay, Ms. Sun,
Son, yes.
Mr. Court,
Court, yes.
Mr. Shea,
Say yes.
Mr. Williamson,
Williamson, yes.
Dryden, yes. So it is approved. All right, finding of facts and conclusions of law. Do I have a motion to approve with amendments to number 17?
I have one, well,
That's
let's
okay.
see, one thing that I would feel more comfortable with, number 18, we're talking about impeding the flow of traffic or pedestrians walking within the street. Maybe let's just strike out street and, or further, or just insert further description of the street within, the, what terms did they use? I mean, it just seems like pedestrians aren't supposed to be walking in the street.
Right.
Anyway, I mean, it just seems like they used another term.
Nearby. Or.
Yeah, I just, I mean, it's a cul-de-sac street, and I don't know if that's the, if that's the term we want to use.
For the
but-
residential nature of the neighborhood,
Oh, yeah,
because they're, I mean, that's what they're using.
likely to widen because it's location within the
With
neighborhood.
those sidewalks. So
No, there's no sidewalks.
they have to walk within the street.
Right.
What people do.
Well, how about if you just say, do vehicles to pull out of the travel lane so they do not impede the flow of traffic or pedestrians? And put period there and just don't not say walking in the street. I mean,
That makes sense.
That works.
Yeah, it's okay. Yeah.
so we'll just, and it will put a period after pedestrians.
Sounds good.
Okay. So we want to amend it to say the distance between the garage door face and the edge of the street is over 20 inches or 20 feet, excuse me, providing space for vehicles to pull out of the travel lane so they do not impede the flow of traffic or pedestrians, period.
Okay.
Okay, that work? All right, so I need a motion to approve with amendments to number 17 and number 18. Do I hear a motion?
Court move to approve. That's
Thank you, Mr. Court,
as amended.
as amended.
Williamson, second.
Thank you, Mr. Williamson. Ms. Sun?
Son, yes.
Sun, yes. Mr. Court?
Court, yes.
Mr. Shea?
Say yes.
Mr. Williamson?
Williamson, yes.
Dryden, yes. So the finding of facts and conclusions of law are approved as amended. Thank you, ladies and gentlemen, for coming. Enjoy your day.
So, Ms. Dryden and board, for the next case, which is 45, I've just spoken with the applicant. They didn't realize it was today. They have asked that we continue on because this was a variance that we did probably about a year or so ago. They're comfortable with that, but obviously if you have questions for the applicant for their, for what they're requesting, we would probably recommend that we defer it. But right now, the applicant did say he's comfortable with us moving forward without them being there.
Oh, this is the same.
And yes, it is on.
I remember
And
this is the same exact thing where we had the height of the building.
They're moving it to a different location because what happened is what you guys approved, and when they came in, John and I decided that they need to come back because they're moving into a different location, and just in case if an adjacent property owner wanted to speak in opposition, they would have it, but the last time we supported it too, so we're comfortable moving forward as staff. I think it's just if someone has a question for them, we would probably have to defer it because staff would answer the best we could, but I typically try to tell people, I don't like staff speaking for their business operations when it comes to.
Refresh my memory, what?
Well,
Well,
I don't know how
I
much
guess-
presentation I can do
Yeah, all right.
outside of the hearing. but,
Yeah, let's take we'll
Just
take
take
5
5
minutes, please, 5 minutes. And then we'll come back and we'll do this one. So we are adjourned for 5 minutes. Thank you, ladies and gentlemen. All right, ladies and gentlemen, we will continue. We're going to look at variance number 2025-00045 for property located at 5101 Westinghouse Boulevard.
Madam Chair, if I could just note for the record too, that the rules of procedure do provide that the board may proceed on this, even if the applicant is not present. I do agree with Solomon that, if you have questions for the applicant, that better practice would be to defer it. But I just wanted to note that the rules of procedure do allow us to proceed.
Okay, thank you.
All right, this is a variance VAR 2025-00045. Stephen Wilson of Gray AES PSC is represented by Brian Sin of Siemens Energy for property located in 5101 Westinghouse Boulevard for property that's owned by Siemens Energy Incorporated. They are seeking a variance from Article 8.3 table or 8.3D table 8-3, which is the building height standards for manufacturing logistics zoning districts. They increase the maximum building height from 115 feet from 80 feet, which is a 35-foot increase for the proposed building. As Solomon mentioned, about a year ago, you guys did see a similar variance request for the same property. And I can show you in the next couple slides, I'll show where the building was originally proposed to where compared to where they're proposing it now. Exhibit 1 is the vicinity map showing the location of the property off of Westinghouse, the corner of Westinghouse and Shopton Road West. And this is west of Highway 160 and I-485 out next to Lake Wiley. Exhibit 2 is the zoning map of the property. It's zoned manufacturing and logistics. And exhibit 3 is the aerial map of the property, existing building here. And then the variance before they were proposing and it basically and essentially an addition to this building. And so that previous variance was for proposed building to be located kind of in this area where this existing parking lot is. You can see there's some existing residential over here on the north side of Shopton Road West. The variance request is from table 8-3. Again, maximum building height for both ML1 and ML2 zoning districts is 80 feet. However, they're asking for a variance to increase that to 115 feet, which is a 35-foot difference. The condition is that the variance will only be applicable to the proposed new building as depicted on the variance site plan. Exhibit 5 is the variance site plan. It shows the proposed building down here south of the existing building. So again, we've gone from up here to down here. So we've gotten further away from that residential uses that are on the north side of Shopton Road West. The proposed eave heights for the area in orange is less than 80 feet. The proposed eave height for the area in blue would be greater than 80 feet, and same for the area in pink, which is an area called the testing bay, and that's greater than 80 feet for that area as well.
All right, so what we approved last year, they didn't build?
Correct. Yeah, they decided not to build it in that location. We don't know why, but they decided not to pursue that addition and building there, and have now since decided just to make it a separate building.
Thank you.
Exhibit 6 is kind of zoomed in on that site plan, just to show the area that a little bit better. So the heights of this area in orange would be less than 80 feet. Area in blue would be greater than 80, and the area in pink or purple would be 80 feet greater than 80 as well. And then exhibit 7 is some building cross sections showing the kind of where those, how it would look, if you're on the ground. And you can see these areas here kind of step up, and then the tallest part of the building is that area in purple, and that's the testing bay area, which has that says 113-foot height. And then the area in blue there is indicated as 85 feet. There's a little roof access that's 91 feet. And then this area in blue down there would also be 85 feet. And then the orange is compliant with the code requirement.
Now, let me ask you, even though they're asking us for a different location, because we approved the variance last year, could they at some point come back and build there? Because that variance was approved? I mean, I'm just curious to know if because now they want to move it someplace else, which, okay, whatever their reasoning, but then could they then in 2 or 3 years decide, well, we want to build something there and we do have the variance, could they do it?
So I would say yes, because technically they have not given up that variance yet, so it would be. Now the property has two variances, so in theory, they could go back because it was a valid approval.
Okay,
Now, what would happen is, I think at the time they got approved, I thought we had something that said it might expire, so at some point, if it expires and they don't do anything,
Variance expire after 3 years,
something like that.
according to the
Okay.
ordinance,
So-
if they're not acted upon.
okay. I mean, that was just curious.
That's a good question, but would staff have a problem if they did build 2 towers?
I don't think so. We were recommending the previous one and you all voted in favor of
Right.
it, so. I think from our perspective, it was, still supportive, and then whether or not there's 1 or 2 buildings that are over 100 in a site this large, I don't think it would really be.
Yeah, this is 292 acres. I mean, it's not like,
Yeah, and I think we would be more concerned. I mean, we were concerned because obviously the original one was the neighborhoods across the street, but we, when we showed you guys that it was really far back, and again, Siemens does. They do a lot of electrical work, so when they came in with a Faraday cage showing what they needed, it's like, it makes sense why they need it for what they do.
Mhm.
So Exhibit 8, again, is just a kind of a 3-dimensional rendering of that same building, showing the building heights and how the building kind of steps up to that total of, we're giving them a couple of extra feet of 115 feet, but that 115, 113 foot portion of the building would be there.
is that staff graphics?
These are the applicant graphics.
I wanted to stand up and applaud there for a second.
Don't get too crazy.
As part of the application, they provided some kind of technical documentation showing how they do the testing in this facility. And they have this area that's basically like a Faraday cage. This is like one of those things that, on a smaller scale, you can touch, and the electrical lines touch your fingers. That's kind of what this is, and it basically controls how they test these generators that they're building. And then there's a crane that runs along to this to kind of shift the transformers along the production and testing facility. And so this is just showing that they need that additional building height so that their mechanical operations are separated from the area where the testing is occurring. Slide 10, exhibit 10 is again considerations in showing the distance from the residential use. And with this change, they are now over 1,700 feet from the residential properties along the north side of Shopton Road West. And there's quite a bit of wooded area along the road, and then some open space and parking and everything else that's would be between this building and those residential uses. Slide 11 is the variance criteria, and all 4 of those will need to be met in order to grant the variance. And I'll give you all a minute to look at the findings before I continue.
You can continue.
All right. So unnecessary hardship results from the strict application of the ordinance. The UDO does not provide the ability to increase the building heights with an increase to setbacks, and the development bonus standards in Article 16 don't apply to the ML zoning districts. So strict application of the height limitation would prevent the construction of the proposed facility, which requires interior clear heights of up to 100 feet to safely house overhead cranes and maneuver large power transformers. The ordinance limitation would effectively prohibit the proposed industrial use. Hardship results from conditions that are peculiar to the property. Hardship results from the conditions that are peculiar to the historic utilization of the property prior to the implementation of the UDO and the unique manufacturing process and needs for this facility. A manufacturing facility has operated on this site since 1968, and the existing 100-foot tall building was constructed in 1997. And I'm going to quickly go back to this bird's eye image, and you can see these existing buildings that are already tall, and I'm not sure which one, but one of these is already 100 feet tall. The proposed building contains an electrical test bay for transformer equipment, and testing can result in energy being released, and the increased height allows for grounding systems similar to a Faraday cage. and ensures that equipment within the building remains outside of the dispersion zone, protecting it from potential damage and enabling uninterrupted operations. And the subject property is developed with heavy manufacturing, specifically the production and servicing of large power transformers. This is unique and requires building heights and crane capacities that are not typical of general industrial facilities. And I can't read the rest of my line. What line are we on here? Let's see, the need for additional height is therefore inherent to the property's specialized function rather than the generalized request. That's number 15 in your findings of fact document. Hardship does not result from actions that were taken by the applicant or the property owner. The hardship results from the strict application of the ordinance and the unique nature of the technical requirements of the transformer manufacturing process. Applicant is constrained by engineering and safety standards that dictate height for crane operation, transformer clearance, and testing functions. The requested variance is consistent with the spirit, purpose, and intent of the ordinance, and that public safety is secured and substantial justice is achieved. Without the variance, the electrical testing functions of the existing manufacturing use could not be accommodated. Granting the variance will allow the property owner to develop property to be developed in a manner consistent with its industrial zoning designation, supporting manufacturing use and continued investment into the site by Siemens Energy. The variance does not alter the essential character of the ML2 zoning district and is aligned with the ordinance intent to accommodate industrial uses while maintaining safety and orderly development. The applicant has offered and agreed to the condition that the variance is only applicable to the proposed new building as depicted on the variance site plan. The building is approximately 1,700 feet from the neighborhood 1 place type, and the previous ordinance allowed for building heights over 80 feet with increased setbacks. And there's an existing building over 100 feet on the site. And the variance will not alter the essential character of the nearby neighborhoods. Here's a sign on exhibit 14 on the sign on the property. And I'll take any questions if you have any.
Questions? Or a motion to approve?
They're the only property owner around the lake there, right? I mean, there's not like a. So what's the big?
So to the southwest is, I guess, property that's owned by Mecklenburg County. It's colored green on tax maps. So that usually indicates county-owned land.
Gotcha.
Wingate Park.
So it's a county park.
Yep.
Where is this in proximity to the county park?
It would be here. So park is down here. The proposed building would be kind of in this general location here.
No conditions, right?
Only that it'll just apply to this variance,
Specifically.
just applies only to the site plan that they submitted.
Yeah, so kind of going back to your questions earlier about the previous variance, the way we set this one up and the applicant agreed and offered to that condition is that basically it's site specific to this. So if they deviate kind of from that general location, then they would need to come back before you all for another variance. This would only be applicable to this proposal.
I would make a motion to approve the variance with staff's condition.
Okay. All right, I have a motion to approve with staff recommendation.
Williamson second.
All right. Ms. Sun,
Sun, yes.
Mr. Court,
Yes.
Mr. Shea,
Shay, yes.
Mr. Williamson,
Williamson, yes.
Dryden, yes. So it is approved
With the condition.
with conditions that staff recommended. Being that the variance is only applicable to the proposed new building as depicted on the variance site plan. All right, do I have a motion to approve the finding of facts and conclusions of law?
What was the change that John made? Did he make one?
I don't think I made one.
No,
No.
he was just reading from. He was just finding his place on our notes. And because it says in here in number 21, the applicant has agreed to the condition that the variance is only applicable, blah, blah, blah. So they've agreed to that. So do I hear a motion to approve the finding of facts and conclusions of law?
Court move to approve.
Thank you, Mr. Court. Do I hear a second?
10 second.
Ms. Sun, thank you. Mr. Williamson,
Williamson, yes.
Mr. Shea,
Say yes.
Mr. Court,
Court, yes.
Ms. Sun,
Yes.
and Dryden, yes. So the finding of facts and conclusions of law are approved as written. Okay. All right, we do have to look at the minutes, and I will remind the board that our next meeting is December the 16th. It's the Tuesday, December the 16th.
John, have any of the applicants
I'll take
that come to
one
you
because
this
I'll
time of
keep
year,
one.
do they appreciate moving this up? Do they prefer we move back? Have they said anything to you?
I don't think we've had any kind of feedback with any applicants related to the timing of the meetings in the holidays season, but I would imagine they're probably appreciative of that too.
Just curious if they said anything to you.
We do have, I think we have potentially five cases for that.
Well, plus the,
And traditionally, I mean, all the years I've been on here, I've never heard anybody complain about us moving it away from those two holidays.
yeah,
Because if we're gonna, because worst case scenario, if someone's complaining, then we're saying we're bumping you to January because.
Yeah, yeah. yeah.
So it's, most people are not gonna have a problem if they're waiting for something.
Especially since I mean, we talked about this back in September. You know, we set these dates in September, so everybody kind of knew that they were coming up. Okay. Do I have a motion to approve the minutes after you've looked at them, please?
Court move to approve the minutes.
Thank you, Mr. Court. Do I hear a
10
second?
second.
Thank you, Ms. Sun. Mr. Williamson,
Williamson, yes.
Mr. Shea,
say yes.
Mr. Court,
Court, yes.
Ms. Sun,
And yes.
Dryden, yes. So the minutes are approved. And that concludes the business of the UDO Board of Adjustment. Thank you very much. Have a lovely Thanksgiving, everybody. Please don't talk. Right there. Oh, but it's gonna be Christmas. I'm like, we just